Welcome everyone who's joining us for the workshop today, the North Carolina Bar Foundation workshop, Hot Topics in Employment Law. We're gonna give the Zoom webinar a few minutes to let attendees trickle in. I can see they're still coming, so we'll give it one more minute or so, and then we'll get started. So thank you for being here. We're excited about the topic today, and just give us a few minutes to get everybody in the room, and then we'll get started. Thank you. Okay, let's go ahead and get started, shall we? My name is Paul Vaughn. I'm with the North Carolina Bar Foundation, and we're excited to bring you a workshop today on hot topics in employment law. Our presenter is Lisa Gordon-Stella of the Law Office of Lisa Gordon-Stella, and we're gonna hear her present for the next little while on some important issues. We want to remind you, everyone, to please, if you have questions, use the Q&A function on your Zoom screen. Also want to thank our partners who have helped put all this together. First, North Carolina Bar Foundation and the North Carolina Bar Association, Mountain BizWorks, the Small Business Center Network, and Prospera. Thank you for letting folks know and for bringing in folks from your networks to be involved in this. We are very appreciative. So on that note, I will turn things over to our presenter, Lisa Gordon-Stella, thank you very much for being here today. We know that this is something that will help lots of folks. So thanks a lot, and I'll let you take the mic.
Thanks. Well, thank you for having me today. It's my pleasure. And before I begin, I'll just tell you a little bit about myself. I'm obviously an attorney. I've been practicing here in North Carolina since 2001, 2002. And my practice today focuses and has focused for probably the last decade on small businesses, nonprofits, and schools. And so my goal today is to give you information that you find useful. And so hopefully we'll get through the entire presentation. If we don't, what's more important to me is to take your questions and concerns than to get through my slides, because this is about providing you value and information that is helpful to you. There will be natural breaks in the presentation because it's divided into a number of topics, and we'll try to take questions during those natural breaks. This PowerPoint, I believe it will be shared with you, and you should use it as a resource. That said, the law is an ever-changing environment, and so what we talk about today may not be the case in a month or a year. And so I would always make sure to check further if you actually are confronted with some of the issues that we talk about today. So the topics that I'm planning to cover are the Fair Labor Standards Act, which is going to apply to anybody who has an employee. And I'm also going to talk about sort of some of the key issues that come up with that, which is the idea of someone being an exempt or non-exempt employee, or particularly for small businesses, a contractor versus an employee, and the implications of that. I'm also going to touch on the Americans with Disabilities Act. Now, I recognize that many of you probably aren't going to fall within the confines of that act, but it is also good for you to know what that act says and when you might actually have to comply with that act. And then lastly, we'll talk a little bit about record keeping and personnel files. And again, if there's a lot of information in these slides, so if we don't get to the last part of this presentation, the presentation itself will probably be very useful to you. I'm hoping to get through it, but again, I really want to provide value to you and answer the questions that you have throughout this presentation. So let's talk a little bit about the Fair Labor Standards Act. This is a very basic fundamental that everyone who owns a business should be aware of. The Fair Labor Standards Act is what establishes minimum wage. It establishes overtime. It also establishes rules for child labor and puts requirements on you about record keeping. It affects virtually any employer in the United States, whether you have full-time employees, part-time employees, and whether you are part of a government or quasi-government entity. So it's really important that you understand the rules of the road when it comes to the Fair Labor Standards Act, because violating it can get you in some trouble. It's also really easy to get in trouble under the Fair Labor Standards Act, which we'll talk about. So here are some of the basics, and many of you may already know this. We have a federal minimum wage, which is $7.25. In some states, I'm also licensed in California, where they have a state minimum wage that is higher than the federal minimum wage. We don't have that here in North Carolina at this time. Generally, under the Fair Labor Standards Act, if somebody is a non-exempt employee and they work over 40 hours in a week, they get time and a half. And again, it's over 40 hours in a week, not necessarily more than 8 hours in a day. Those are distinctions that matter. The law makes a distinction between what an exempt employee is, who you don't have to pay overtime to, and what a non-exempt employee is, somebody you have to pay overtime to. And the law also establishes that wages are due on a regular basis, and it provides some parameters for that. So I'm going to just talk about something that has come up. I like to put my presentations in some type of context. So I have clients that have called me, whether it be a nonprofit or a small business, and they want to possibly have someone work 2 different jobs or share jobs. So this is a hypothetical that I was actually faced with, which is what happened, it's actually not a hypothetical, it's a real world situation where you have a receptionist that is working a certain amount of hours a week, and then on the weekends or in the evenings, they're also serving in some other capacity. How would you classify this person? So the client that I was working with wanted to declare that in the evenings and on the weekends, what that person was doing was more of an independent contractor position and not someone as an employee that would be an employee of the school. They were actually, it wasn't a school, it was a small business. I apologize for that. But the reality is, these are the questions that we have to look at when you're faced with these types of issues. How many hours a week were they working? Do they have two different, can you avoid paying overtime by putting someone in two different jobs? And could you classify someone as an independent contractor as opposed to an employee? And the answer is that the person is under the Fair Labor Standards Act, is a single employee. Doesn't matter that they're working two different kinds of jobs. It doesn't matter that they're working different hours. It doesn't matter that you want to pay them differently for the different kinds of jobs that they have. You have to track their time and you have to pay them. And if they work over 40 hours a week, you have to pay them overtime. So the Fair Labor Standards Act is something that you can't really, there's not really creative ways to get around that 40-hour-a-week overtime. It's also the case that for that particular employee, what they were doing also wouldn't qualify as an independent contractor position. And so you couldn't parse it out that way. In fact, the law is pretty unfriendly to those type of arguments. So I understand entrepreneurs are inherently creative. This is not a way in which you want to be creative. You really want to follow the rules. So another component of the Fair Labor Standards Act is, what do you do if you want to share an employee with someone? Or how you might accidentally be sharing an employee with someone. I had a nonprofit that wanted to share a receptionist with another nonprofit. And there are rules that go into place that make you liable for those joint employer relationships. I'm not going to go into, because I don't think it's that useful for you to go into how you determine if someone is a joint employer in joint employment. But what you need to know for purposes of operating your business is that you can't just share employees without having legal repercussions. There are legal repercussions to trying to share employees. And you have to be aware of that when you're operating your business. It might be cost effective, but it also might end up not being cost effective because of the fact that you may be liable for some of the other employers' actions. Minors. So as I said earlier, one of the things that the FLSA regulates is how minors can work and what hours they can work. And this slide does a pretty good job of explaining that once someone is over 18 or over, they can do any job that they choose to do and that you want to hire them to do. But when you have minors that fall into the 16 or 17-year-old age range, or certainly the 14 and 15-year-old age range, there are very specific restrictions on what they can and cannot do. And you have to make sure that you comply with those restrictions, including, as I said on here, the number of hours a week they might work, the types of hours they might work. Now, all of this is to say that if you are employing a family member who is a minor, there may be different rules that you are dealing with as opposed to someone who is not a family member. So I'm not covering that today. This is just generally if you just hire a minor to work at your workplace, that there are going to be rules that apply to them. And why does this matter to you? I'm going to tell you why it matters. There are big fines that can be levied. There is a very recent and what has become sort of an infamous case with one of a popular fast food restaurant, Chipotle, where they were fined. They were subject to the greatest labor violation for violating child labor laws in Massachusetts history this year. And what ended up happening was parents reporting that their kids were being told they had to work. And this was a systemic problem throughout their locations in Massachusetts. and they were levied a fine of $1.3 million. Now, certainly none of you are Chipotle, but what that means is you have to think about the fact that you could be walking yourself into a problem if you are not complying with these very clear guidelines that and rules that have been issued under the Fair Labor Standards Act with respect to child labor. So one of the things that you should be aware of is, what does it mean if you violate the Fair Labor Standards Act? A few things to think about. So first of all, if someone believes that you violated the Fair Labor Standards Act, an employee or a parent, it is very, very easy to make a complaint. You can go online to the North Carolina Department of Labor and make a complaint online. It doesn't take but a few minutes of time to do so. And at that point, if the Department of Labor, they have to look into it. And if they find that you violated it, you can be liable for back wages and also additional damages. An employee could also file a private suit against you. That is usually less likely for smaller amounts of money because it costs money to litigate, but it's certainly something they can do. And the Department of Labor can also get involved in levying additional actions against you if you fail to comply. Now, here's the key to keep in mind. The statute of limitations, meaning the look back period for violations, is typically 2 years. However, if it's willful, then they can look back 3 years into your books to see. And oftentimes people will allege that something is willful. What might be willful is if you knew about the violation and yet you continued to do it. That would be considered willful and allow them to go back and audit your books for 3 years. And if you know or have heard of anyone who's had a Department of Labor audit, it is a very, very uncomfortable process. And it is not without both cost mentally and then cost potentially out of pocket monetarily. So you really do want to avoid this if at all possible. Here are the penalties for overtime violations. It is $1,000 for each violation. So if you have found to not paid someone appropriately 10 times, that's $10,000. And then there are other violations, particularly harsh violations, as I said, for violating child labor laws. And there's also the possibility, and while it's remote for usually small businesses, but you can have criminal prosecution if you violate the Fair Labor Standards Act. This is an issue that comes up a lot for employers, regardless of size. And that is, let's just say that you have someone who comes to work for you and you let them use your equipment or a uniform, or you give them a phone, whatever that might be. Well, and you want them to pay that back to you, okay? Either because you're going to take it out of their paycheck because they're getting this phone and they're going to pay a certain amount every month, or they don't give it back to you at the end of their employment with you. So I have had numerous clients ask me, well, can I just deduct the cost of that item from somebody's paycheck? Or can I hold their paycheck? So the answer to both of those things is no. Okay. So if, let's say, for example, you're going to give someone a uniform or tools of the trade, you want to take that out of their paycheck, you must, North Carolina Department of Labor requires that you get a specific written authorization. And in that written authorization, it has to have the exact amount of money and what you are deducting for. It also must provide that the employee can revoke that authorization if they so choose. And the authorization, and so if you want to do that at the front end, because you're giving something right out of the box to an employee. However, what about the back end? Someone's leaving and you want them to give you back a phone or a computer and they refuse to do so. Unless you have a contemporaneous authorization for that phone or computer, you're not going to be able to deduct that from the paycheck. And even if you do, it's very important that you understand, particularly with technology, you cannot deduct it full freight from them. And what do I mean by that? So computers and phones are not worth today what they were worth a year ago. So if you give someone a brand new phone and they work for you for 1 or 2 years, you can't deduct the full cost, even if you had an authorization to do so at the back end. So let's just say you had them fill out an authorization that says, if you don't return your MacBook Air, then the company is going to deduct the cost of that, the receipt of which is, and you have a receipt attached to it. Well, you might be able to do that if it's a couple months out, but if it's a couple years out, you're not going to be able to use that authorization, because that computer is no longer worth that amount of money. So it is important that you periodically update your authorizations to make sure that if someone leaves and doesn't return property, that you can take that out of their paycheck. Now, let's just say you don't have an authorization, which is not uncommon. What do? Can you deduct it from their last paycheck? You cannot deduct it from their last paycheck. That is looked upon very, very badly by the Department of Labor, and you can get in big trouble for doing that. So what can you do? What you can do is you can tell the employee that that is not their property. And of course, you should make sure at the front end, when you hire the person, that you make it clear that you are giving them certain property, that they sign a document evidencing that they've received this property and they promise to return it. Now, and that the property is company property. And then if they don't return it, the reality is that you could tell them, hey, guess what? If you don't return this property, I'm going to file a report with the police for theft. For the legal term might be conversion, because they have not returned the property. And that is a real threat. Is it going to get your property back? I can't guarantee that it will, but it is certainly the case that that is a crime to not return and to steal a company's property. And so it is a legitimate threat. Be careful when you do it, because you want to make sure you have the authority to do so, that you're not just making a blanket threat. And also, you want to try to work with the employee and never get to that point. But I can tell you right now, I'm actually this morning, or actually yesterday morning, had to write a letter much to that effect, because an employee was refusing to return property that was clearly property of the employers. So these are very important issues for businesses, particularly for small businesses. And it's very important that you navigate them appropriately and have under your belt the proper documentation to support a return of property. Tipped employees. I'm bringing this up just so you have it if you happen to run a business where you have to provide people, where people are getting paid with tips. And this slide pretty much sums it up, that there is a difference in the minimum wage in North Carolina for tipped employees versus non-tipped employees. That employees are required to retain their tips unless you have some type of valid tip pooling or tip sharing arrangement. In other states, there aren't necessarily differences in minimum wage for tipped employees and non-tipped employees. California being one of them, it is the same minimum wage regardless. So I point that out to you in case you have an employee who is operating under information that may not be accurate, so that you understand what your legal requirements are. And in North Carolina, there is a difference in the minimum wage. Comp time. So I'm sure many of you have heard the term comp time. And what comp time means is it's when an employee is given time off in lieu of being paid overtime. And I will tell you that I've had quite a few small businesses and nonprofits come to me and wanted me to review something. And in so doing, I learned that they had this comp time policy, which instead of giving people overtime, they gave them time off. You cannot do that. The only people that can give comp time, well, the only entities that are allowed to give comp time are government employers. No nonprofit, no private employer can use comp time in lieu of overtime. That is a clear violation of the Department of Labor laws and the Fair Labor Standards Act. So if someone is working overtime, you can't tell them, oh, I'm going to give you a day off next week because you worked overtime last week. You just are not able to do that under the law. And it is something that sometimes sometimes employees want that. And employers don't understand that you can't do that. And I will say that's been a theme for me with a lot of small businesses in particular and nonprofits, is that folks feel like, oh, well, if you agree to these rules with your employee, then you can just agree and do it that way. Well, there are lots of things as an entrepreneur you can agree to with your employees. There are certain things, however, that you can't. And this is one of those things. You cannot agree to pay someone to not pay overtime and give someone a day off instead. You cannot agree that someone, and we'll talk about this in a minute, is an exempt employee when they're technically a non-exempt employee. The law supersedes certain agreements that you may want to have with your employees that you cannot have with them. And so it's very important to be cognizant of where the parameters of your creativity and discretion lie and where they can't go. And this is one of those places. So all that being said is, in North Carolina, the Fair Labor Standards Act does not require any of the things on this page. It doesn't require you give vacation, holiday, severance, or sick pay. Now, at this moment in time, as a small business under COVID until the end of 2020, there are requirements for sick pay, but that is not part of the Fair Labor Standards Act. That is part of the Family First Coronavirus Relief Act. So, but the Fair Labor Standards Act does not have these requirements. It doesn't require you give a meal or rest period, vacations or holidays off. It doesn't require premium pay on holidays or weekends. And it doesn't require a notice or reason for terminating someone. That's just not what is required. So these are the things that you have discretion with. Obviously, it's a competitive marketplace. You might want to think about what you want to do when you do that. And also, you're human, and we want to treat each other with fairness and dignity. And so think about that, obviously, when you can think about what you should do versus what you have to do and what you can do. And those are all different decision points. But the Fair Labor Standards Act does not require all of these things. I will point out in the fifth bullet point, so if you terminate someone or they quit immediately, you don't have to immediately give them their paycheck. They do have to get their paycheck, though, at the next regularly scheduled time. And why I'm bringing that up is, in some states, there is a requirement for an immediate paycheck. We are not one of those places. So you do have to give them their final paycheck, and you have to give them their final paycheck along the lines of when you would normally give them their paycheck, which is not necessarily the day of discharge. So the next area that I wanted to talk about, and maybe we'll take a second to pause and see if there are any questions up to this point before we move on.
Hey, Lisa, we do actually have one question from an
Sure.
attendee. She asked, if an employee is staying in an employer-furnished lodging and causes damage or theft, what are the employer's rights for recovering the cost of the damage or the theft?
So that is a great question. A lot of that is going to depend on what agreement you reached with that employee when you hired them. And so if you have a situation, like, for example, I recently drafted a contract for an employer where they are having an employee stay have lodging at the employer paid lodging. And in that agreement, we made it very clear that they were liable for certain damages, that we also opted to pay for insurance, for renter's insurance for the employees, so that there could be no claim against the employer if something was stolen from the employee. But a lot of it has to be dealt with at the front end on when you hire that person and provide that benefit. And I would be very careful in how you do that. The other thing to think about in those types of arrangements is whether the employee is, if you are not charging the employee rent for the space that they are staying in, that can become a potential IRS issue as being a benefit to the employee that they have to pay taxes on. I would certainly encourage you to talk to your CPA or accountant about it, because that's a pretty complex area. There are certain rules that apply to that you have to fall within to have it be such that the employee wouldn't be on the hook for potential taxes if it is, again, if they're not paying rent. But again, all of that has to be spelled out in an agreement that you have with the employee, and it should be done at the front end. Of course, if someone trashed the property, I would imagine that you would have recourse, through either the criminal system because they destroyed property. You could have some implied agreement that you could use, but really your greatest protection is to do it up front so that you know the parameters of the relationship.
There's a follow-up question to
Sure.
that. In that agreement, if you make the agreement on the front end, are you allowed to say in that agreement that you will withhold the value of the damage and theft from their paycheck?
I do not believe that you could do that, because the problem with that scenario is you could require them to agree to an authorization to take it out of your paycheck. But North Carolina is very specific about these deductions from paychecks. You have to have a specific deduction form that sets out the amount before you can take it out of someone's paycheck. And so that agreement would likely not be sufficient in and of itself because you don't have a quantifiable number in there. You could tell them that they must execute an authorization to deduct and agree to, but then obviously that's the challenge. You could hold a deposit. I mean, there are other ways that you might do it, but I get very nervous when I start thinking about deducting from people's paychecks because the Department of Labor frowns upon deduction from paychecks. And it's very hard to comply with their rules, and it's really easy to get in trouble. Any more?
I think that's all of our questions for now.
Okay, great. All right, so I'm going to hop on to a couple of more topics that I think would be really helpful for you to know. One of them is exempt and non-exempt employees. Those are legally defined. If you recall a few minutes ago, what I said was there are certain types of relationships and certain types of rules that you cannot alter through an agreement with your employees. Exempt versus non-exempt is one of them. Independent contractors is another one, but you can create jobs and you can create agreements and tasks that would meet the definition of independent contractor. And we're going to talk about what an independent contractor is. And the last bullet point I just wanted you to know about is, people say there are different other types of workers. You have full-time, part-time, seasonal, temporary, probationary. All of those types of words are defined by you. Some employers say that if you work over 30 hours a week, you're a full-time employee. Some say 35, some say 40. Some say part-time is 20 hours a week. Those are all within your discretion to define. What's not within your discretion are the two bullet points above that, exempt and non-exempt, and and largely what constitutes an independent contractor. Everything else is up to you to use your creativity on. So I have a lot of slides on exempt and non-exempt. I'm not going to go through all of them, but again, I thought these would be useful synopses for you to have if you ever need to look at it. This is one area that has changed over time. We had an update to the Fair Labor Standards Act this year, which is included in this presentation. And there is nothing to say there will be one in the future, but this is where we are today. So as I said, non-exempt employees are entitled to overtime. Exempt employees are not. what makes someone an exempt employee versus a non-exempt employee? An exempt employee is someone who is paid at least $35,568 a year or $648 a week. They are paid on a salary basis and they perform certain types of job duties. And there are 5 categories of job duties. There is the executive, the administrative, the professional, the outside sales employee, and then some computer employees. But I want to say this right now, if you take nothing away from this, but what I'm about to say about exempt versus non-exempt, the title of the employee does not matter for exempt or non-exempt. What matters is what they actually do. If you call a secretary a vice president, they're still a secretary under the law. So you have to make sure that you're looking at not what the title of the person is, but what they actually do in making these determinations. These categories are categories of job duties that allow them to be classified as exempt. They are not titles that dictate whether they're exempt. So the executive exemption, as the name would suggest, and is likely any of you as entrepreneurs, as someone in starting a business, you're going to be an executive if you were drawing a salary at all. But that's where you would fall under. And an employee, to be an executive, you have to be somebody whose primary duty is to manage the enterprise. You also must direct the work of at least 2 or more full-time employees or their equivalent. And you must have the authority to hire or fire other employees. Okay. And this is sort of the crux of that executive exemption. So again, when I said you can't just call a secretary, someone who has secretarial duties, a vice president, is because that person who has secretarial duties isn't doing these things. So what matters is that these responsibilities fall within the executive. And if it does fall within that, then the person is an exempt and is not entitled to overtime. You know, all of this also requires that they're being paid at least $35,000 plus per year. The administrative exemption. And this is where we have the most confusion for people, because it's called an administrative exemption. So people think, oh, I've got my office manager, she can be or he can be exempt. But that's not necessarily so. Again, you have to look at what they do. It is really designed for a high-level employee whose job is to keep the business running. It is not designed for someone who's doing data entry or who's just welcoming people into the door of your business. Okay. And the components of this are they have to work office or non-manual labor directly related to the management or general business operations of the employer or the employer's customer, and a primary component of which involves the exercise of independent judgment and discretion about matters of significance. The crux of this is they have to have independent judgment and discretion about matters of significance. What type of lunch to order, while might be important, it is not considered matters of significance. What type of paper to buy, what type of pens to purchase, those are not going to be matters of significance. So this person, when you say administrative exemption, has to really be someone of a high level. And it cannot just be somebody who is doing clerical work at your company. So it's very important that you realize that. The professional exemption, this is pretty obvious and clear. It's someone who's in either a learner profession or a creative profession. Someone who is like a graphic designer would fall in this area. Obviously an attorney or a physician or a teacher would fall in this area. But it doesn't have, but a professional is not just learned professionals, it's also creative professionals on the artistic side. The outside sale exemption, this is a fairly complicated exemption. I've sort of tried to boil it down to its essence here. But one of the main components of this is that they are regularly engaged in work outside the employer's place of business. Now, let's be honest about this right now. In a post-COVID world, it will be interesting to see how this gets interpreted. But just so you know, this does exist. The computer-based exemption, these are high-level computer high-level computer jobs. It is not someone who's just doing data entry or basic computer programming. And I will say that of all the aspects of the exempt and non-exempt rules and statutes, the unfortunate thing for you to know is this computer-based exemption, I believe, has not been updated in something like 20 to 25 years. And it was written by Congress. So it is not it's probably not what we would ideally want to see in this type of exemption, but it's what we have to live with. And the last thing to keep in mind is this when you're thinking about exempt and non-exempt. Remember, I said someone to be exempt, you have to make over a certain amount of money. And it's, roughly a little under $36,000 a year. Well, let's just say you have someone working and they're making $70,000 a year. Well, they still don't get to be an exempt employee if the job that they do is considered a manual labor or a blue collar job. So if someone is performing work involving repetitive operations with their hands, physical skill and energy, they do not qualify for being exempt employee, even if they make over the $35,000 and change threshold. And I will say, I've worked with companies where they have people making in the six figures who are still considered blue collar workers, and they cannot get them classified as exempt. So again, exempt is something that you cannot deem on your own. There are rules that govern what is exempt and non-exempt. Any questions, Kim?
No questions right now,
Okay.
but I'll stand by. So anybody who's listening or watching, oh, there we have one. Okay. So attendee has a tile and stone business.
Okay.
Does this mean that even the two co-owners are non-exempt?
No, if they're co-owners of the business, owners are not subject to exempt, non-exempt. It's about people that are W-2 employees as opposed to partners or owners in a business. But that was a great question.
Yeah.
So the last part of the Fair Labor Standards Act that probably is going to be one of the most important parts for you as small businesses is the rules regarding deeming someone an independent contractor. And I wish that I could give you a single factor or a single measure by which to determine whether or not someone is a contractor, but I don't have one for you because we don't have one as lawyers. The Department of Labor and the IRS instead do what we call a certain factor test. And there are numerous factors that they look at in determining whether someone should be treated as a W-2 employee or as a 1099 independent contractor. And as you probably know, there are legal implications for that. Someone who is a W-2 employee, you have to pay their Social Security and Medicare parts of that. You also have to have your workers' compensation. There are rules that govern once you have that W-2 employee that don't govern when you have independent contractors in North Carolina. Now, again, in other states, there are other rules, California being one of them. But for North Carolina, if they're an independent contractor, certain benefits don't accrue to you. So how do you determine if someone is an independent contractor? So I highlighted what I believe based on the case law and what the guidance from the IRS and Department of Labor have said, which is what is the degree and nature of control by you, the employer? If you have a lot of control over when someone does something, what they do and how they do it, they are going to be your employee, okay? However, if there's someone who is maybe project-based and they are doing a task, they are doing a project like designing your website or doing your social media, and maybe they do it for other people, then if they are not told they have to do it, at a certain time, a day or a certain number of days, and they have a lot of discretion, then they're likely not going to be an independent contractor. It also, you want to look at, does that person have other people that they work for doing this same business? How permanent is the relationship? And what type of, what is their opportunity to make money at the company? So it is a factor test. It is not, unfortunately, just something I can give you yes or no, this person is and this person isn't, like I could with exempt versus non-exempt to some degree. But think about when you were thinking about bringing someone on and you're saying, oh, I'd like to bring this person on as a contractor, how much control and what is the nature of their relationship to your company? That is honestly the first question I ask every single client that I have when they tell me they're bringing in an independent contractor. And we go through this analysis together to come up with a way to justify the decision that is made. If you make the decision to make someone a W-2 employee, the odds are there's not going to be a problem from the Fair Labor Standards Act. The issue only arises that you need to justify yourself if you want to have someone as a 1099 employee. The last couple slides on this issue are just going to talk about the fact that misclassifying people as exempt or non-exempt or a independent contractor when they should have been a W-2 employee is actually very costly and can cause a lot of trouble. There has been much in the way of litigation and fines over the exempt, non-exempt, and over the independent contractor issue in the past years. So again, it's something to keep in mind that you want to make sure that you comply with. And then the last slide here is about what you need to do as a small business to keep track of what records you need for the Fair Labor Standards Act. And that's a slide you can use to make sure you're complying with it. Kim, are there any other questions that people have? I think because we're going to move on to a second topic.
No questions right now, but if anybody would like to type one into the Q&A, I'm glad to read them.
All right, we'll continue on. If you think of them, please put them in the chat. So I'm going to talk about the Americans with Disabilities Act, and I'm talking about it today because while it might not apply to you today, it might apply to you at some point in the future. And it's also important for you to know what you don't have to do sometimes as much as what you have to do. If you are a company that has less than 15 employees, then you do not have to comply with the Fair Labor Standards Act. However, if you have 15 or more employees, and that includes full-time and part-time employees, then you have to comply with the Americans with Disabilities Act. I apologize, misspoke. And this particular area of the law with COVID has become a huge issue. I think I spend hours every day talking with small businesses and nonprofits about the Americans with Disabilities Act right now, and things that you might not think fall under the Americans with Disabilities Act do fall under the Americans with Disabilities Act. So for example, I've had businesses ask me, we have a positive COVID case, can I tell other employees who had COVID? Or is it a HIPAA violation? Well, here's the thing for you to know. Most employers, most small businesses are not HIPAA covered entities unless you're a healthcare entity or related to healthcare. But if you are a restaurant or a grocery or a flower shop or you're brewing beer or you do technology, HIPAA doesn't apply to you. But what might apply to you is the Americans with Disabilities Act, which says you can't disclose health information about people. And guess what? Health information includes a positive COVID test. So you cannot disclose to the employees who were potentially exposed that there was a positive COVID test. What you have to do instead is you can say to people, and I have template letters that I've provided to provide parameters around this, which is, you have been potentially exposed to COVID, and the steps that you need to take, but you can't name the person. So I bring that up to say there are things about the Americans with Disabilities Act that you might not realize apply to you and come up in day-to-day operations in your business. But again, it only applies once you reach that 15 employee threshold. That's 15 total employees, whether they be part-time or full-time employees. And what the Americans with Disabilities Act says is that you cannot discriminate against an employee because they have a disability, and that you have to, and what a disability is incredibly broad. And I'm going to say that's why the Americans with Disabilities Act is becoming such a huge issue under COVID, because disability includes someone with diabetes, someone who has high blood pressure, someone who has conditions, health conditions that are not obvious and that you have not have known about, and employees might not have shared, but for COVID-19, because they would like to have an accommodation. So the definition of disability is incredibly broad and is also looked at without the effects of medication or ameliorative measures. So if someone is hard of hearing, they do have a disability, even if they hear better when they have hearing aids. If someone is a diabetic, but it's controlled by medication, they still have a disability, even though it's ameliorated by their mitigating measures. There is one exception to this, and that is someone who wears glasses. Someone who wears glasses is not considered to have a disability. Typically, there might be situations where that reaches the point, their vision issues reach the point of having a disability, but just your typical person who has nearsighted or farsighted would not fall under the Americans with Disabilities Act. So the thing about the Americans with Disabilities Act is the person must be qualified to do the job with or without the accommodation. If the employee is not qualified to do the job, then the ADA does not come into play. And this is why it's coming up with COVID-19 in particular. If you are a workplace where an essential function of the job is to someone to be present on site, and someone says, well, I can't come in because I have a condition that puts me at high risk, I would like an accommodation to telecommute, but the job is not a telecommuting job. Let's just say if you are a grocery store clerk stocking shelves, you can't do that from your house. An essential function of that job is stocking grocery shelves. And so what the ADA requires the employer to do is to provide a reasonable accommodation to allow you to do that job, but you can't do it from home. And so working from home would not be a reasonable accommodation under that scenario. And you would not be qualified for that job. And so this is what the next slide really gets to. And this is frankly the crux of the ADA right now in particular, is what is the essential function of the person's job, and how do you quantify that? And I will say this for all of you, one of the things that will be really helpful to you, and it's helpful not just for the ADA, it's helpful in so many aspects of the workplace, is making sure that your employees have job descriptions. Because how do you know if someone can do the essential functions of their job? Well, what are the essential functions of their job? That is all going to be tied to their job description. It's also the case if you're even, working with people and you're trying to give them feedback on what job, whether they're doing a good job or not, or what they are or not doing. Having a job description is essential to having that discussion. So I am a big fan of job descriptions. They don't take a lot of time to do, and you should do them. You can adopt the post that you put down to hire people. So what's the job description that you created when you posted the job? And you can convert that into a functional job description that's used on a daily basis. And you should update it as you change the job. This slide talks about reasonable accommodations. If someone provides you, and I know that we're getting short on time, so I'm just going to give you just a broad brush here. If someone ever came to you and you fall under the Americans with Disabilities Act, you have to go through what is called the interactive process. And the interactive process means that you have to get information about that person's disability. And there are certain forms that you use that you would give to their medical provider. They would give to their medical provider. The medical provider would fill out, and you would use that form to decide what type of accommodation makes sense, both for the employee in achieving the protections they need, and for you as the employer in making sure that the job that you need to get done is getting done. That document is very important. And even if their medical provider says that they should get a particular accommodation, you as the employer aren't required to give the exact accommodation. The goal is to provide the employee with what they need while simultaneously giving you what you need as an employer. And that's an interactive process. It is not static. It is not forever. It is something that you may revisit over time and might change over time. And it is very important. I will say, if you ever are navigating the Americans with Disabilities Act, please speak to legal counsel, because it can get very complex very quickly, and it can cause lots and lots of challenges. So all the rest of the slides I'm going to touch on really quickly. One slide that I thought was very important for you to understand, because this is where a lot of small businesses can make mistakes, is things that you cannot ask during the hiring process. You cannot ask about age except if someone is under 18, for purposes of making sure that you're complying with labor laws for minors. Other than that, you can never ask about age. You cannot ask about arrest record. You may ask about convictions. However, it is becoming more and more frowned upon to just use convictions as a blanket disqualifier for certain types of jobs. But this slide provides you with just general things that are off limits to what you should be talking about with your employees or with potential employees, and and the problems that you can create for yourself if you do so. And these questions are also questions that I put in there. We talked about return of company property, and how you can protect yourself against that, and how you can't just deduct it from the paycheck. The last few slides are what should go in someone's personnel file. I think it's always important to understand what goes in someone's personnel file. It's also what's important to know what doesn't go in someone's personnel file. You should have a separate file for any drug testing, any background checks, any references. And you should also have a separate medical file for anything to do with the Americans with Disabilities Act. And of course, if you reached a point where you had 50 or more employees, Family and Medical Leave Act, and medical records. So remember, we were talking a bit about how right now, even U.S. small businesses are required to comply with and provide parent people emergency paid sick leave under the Families First Act. Well, you may get medical records from people with respect to that. If you get medical records, make sure those go in a separate file from the personnel file. They do not belong in that employee's personnel file. So I realized I rushed through at the end. Kim, are there any questions?
We do have one more question.
Sure.
And those who are watching can send additional ones if they have them. But the question is, if I have someone completing work as a side job, something less than 20 hours per week based on various projects that come up, and they work full-time for another company, can I, as the employer, consider them a 1099 employee?
It's going to depend on what they do for you and how they do it. I wish that I could give you a yes or no answer. Part of it will also, it's again, that slide is a multifactorial test. It's not simply, do they have another job? It's not simply that they're working after hours at that other job. It's about what type of work you're giving them, what type of expertise they have, how much control, what are the deadlines, what is the type of work? And it involves having a look at it in a more robust way. And I can't, unfortunately, give you, based on that information, a definitive answer one way or the other. Certainly
Sure.
the fact, the more likely someone is to do that, what you're asking them to do for other people, the more likely it is you have less control over them. And the more likely it is they have more control because they're doing it for other people. But even that is not, a definitive answer.
Got it. We do have a question.
Sure.
With our business, we're trying to bring on 2 employees as W-2s, and we're not sure where to find accurate information about withholding amounts. Could you point us in a right direction about how to get started with W-2 employees?
So there are different websites that you can use. I don't have one off the top of my head that I could recommend to you. But there are apps even where you can do, where you just put in the employee's information and their rate of pay, and it calculates how much you have to pay for Social Security and Medicare. It's typically, so Social Security is typically, I believe, it's 7.75% for the employee and 7.75% for the employer payment. And I believe Medicare is 1.45 for the employee and 1.45 for the employer. Medicare never caps out. Social Security does cap out at a certain amount of money that someone would make. It's usually, close to 100,000, might even be more than that. But there are calculators on the web that can do that for you. There are apps and app programs you can buy to generate that. There's even inexpensive software that you can use to generate that yourself. And sometimes if you're using an accountant, they may be able to do it for you, because you should be using, if you're getting into a stage where you're having W-2 employees, particularly more than one, that's really the time to think about having a bookkeeper or somebody who can take on that task for you. It is inexpensive. It's worth its weight in gold so that you're not missing anything, because you also want to make sure that you're going to have your workers' comp, your unemployment insurance, all of those, in addition to paying, getting the W-2 forms. W-2 forms, I believe, are available directly from the IRS, but then also calculating that per paycheck.
Thank you, Lisa. We don't have any other questions at this time,
Okay.
but I want to take the opportunity to thank you. That was really, really wonderful. We did actually have one more question, but I hope to answer it directly. We were asked if the PowerPoint will be made available. So I want to tell everybody that yes, what we will do is email that to you following the webinar. And if you have any other questions, please feel free to reach out to us. You can reach us by email at the email address foundation@ncbar.org. Again, we want to thank our program partners, Prospera in Charlotte, Mount Bizworks in Asheville, and the Small Business Center Network, particularly Community College. We've appreciated the opportunity to hear from Lisa. And again, I want to thank you, Lisa, for being with us. That was a great presentation.
My pleasure. Thank you. Anytime.
Thank you.
Have a great afternoon, everybody. Stay safe.
You too. Bye-bye.
Bye-bye.